Any mention?
May I please, Your Lordship? I beg to mention item number 5. This is a matter relating to land acquisition matter. Praying for 2 weeks' time, Your Lordship.
You're for?
Respondent 3.
Who's respondent 3?
It's a committee, my lord. The committee who has been formed and who has received the compensation. This is a case where compensation has already been received.
Oh, commissioner. And who are you?
Your Lordship, I am for the petitioner.
You're a petitioner, no? But what is your claim here?
Your Lordship, we are representing the claim of the Khunki Hajar who live on the subject property, and we are representing that there were.
Are you the landowner?
No, Your Lordship.
Then?
Your Lordship, we are.
Matter of compensation means, you see, land acquisition and compensation relates to the landowner, title holder, whatever, and the collector or the department concerned.
Yes, Your Lordship. Your Lordship, however, in the land acquisition certificate, we were given a representation that until pending disputes are resolved, the compensation will not be disbursed. On that basis, we have filed this petition, Your Lordship.
Okay, I think we should hear the matter. How long?
Praying for 2 weeks' time, Your Lordship.
Or no more adjournment. Mr. Letter Counsel for the respondent number 3.
3.
Has sought for accommodation on grounds of personal difficulty. Mr. Letter Counsel for the petitioner has no objection to the same. Ms. only appears for this collector. Spread for this matter after 2 weeks.
Much obliged.
May it please, Your Lordship.
Yes.
Lordship, I beg to mention item number 3 and 4. Malad, similar matter is pending before the Honorable Supreme Court, so matter may be listed after 3 weeks, Malad.
And for the respondents, Your Lordship.
Mr. Your name?
M. Sharma. M. Sharma.
Mr. M. Sarma, Letter Counsel for the petitioner, has submitted that similar matter are pending before the Honorable Supreme Court. As such, accommodation is sought for this matter for the day. As prayed for, list this matter up to 3 weeks. So 3 weeks then?
May I please, Your Lordship? I beg to mention item number 1, my lord.
1?
Yes, my lord. It is in hearing list, my lord. I'm seeking 2 weeks' time, my lord.
This is a very old matter.
Old matter.
What's the matter about?
This is with regard to dismissal from service.
Dismissal from service.
Dismissal from service.
And what is your age now?
Yes, I have already passed.
Then?
Although it was parted by Mr. Bhattacharya.
Then the matter has become infructuous.
So no, but
since you have come against dismissal of your service, by now you have your age of superannuation is already over.
No, the problem is because they have freeze my accounts, everything. They have said those points are there.
Pensionary benefits you have not.
No, nothing. So in fact, the entire disparate inquiry is vitiated.
Okay. How long?
2 weeks, my lord. After 2 weeks.
You're for respondent?
All the respondents.
All respondents.
Yes.
Mr. Letter Counsel for the respondents has sought for accommodation. Mr. S.P. Manta, Letter Senior Counsel, has appeared on behalf of the respondent number petitioner. As prayed for, matters adjourned. Lists him after 2 weeks.
3 weeks.
May it please, Your Lordship. Your Lordship, I beg to mention item number 8. Your Lordship, in this matter, we were supposed to file a reply to the objection which was filed by the respondents. I'm praying for some more time, Your Lordship, to file the reply.
On made by Mr. Letter Counsel for the
Appellants, Your
appellant.
Lordship.
Matters adjourned. Lists him after 3 weeks.
Much obliged. On supplementary list, item number 1.
Yes, what is
May I
this
please,
matter?
Your Lordship? Your Lordship, I appear on behalf of the applicant. I was arrested on 30th of June 2023. This is in connection with Joa IPS case number 80/6 of 2023 under section 21A and 21B. The possession that was, the recovery from me was 4.61 grams of heroin, which is a small quantity, and the same bail was granted on 11th of November or September 2023 after 87 days of being in judicial custody.
What's
Now,
the allegation against you?
the allegation against me, Your Lordship, is that my bail was, after being granted on 11/9/2023, I was again arrested with a different case on 18/9/2024. I was detained based on suspicion. The suspicion was because of the fact that the ANTF team at that point in time were doing their routine patrolling. They had intercepted a habitual drug peddler, but it was only mentioned for one drug peddler. However, I was detained. Two persons was detained, and I was one of those persons without being without any inference being made to me as a drug peddler. Now, in this second case, Your Lordship, I was arrested on 19th of September 2024. The search memo and the weigh memo from me was 0.31 grams. This is also another small quantity. Similarly, I was granted bail via order dated 27/11/2024. So after 1 month of me being arrested in my second case, I was granted bail.
So, small quantity.
Yes, Your Lordship.
Are
Now,
you-
right after I was granted
Are
bail,
you a user?
I am a user, Your Lordship. And because
You can take recourse to 64A.
yes, Your Lordship. So we have made a prayer as well for rehabilitation, and that's we have already applied for multiple bails from the trial court. However, it was rejected on two multiple occasions. Hence, we are approaching.
See, if you file an application, seeking recourse under 64A, isn't it? Then question of bail will not come. You will be discharged, and on your undertaking that you will be.
Yes, Your Lordship. So, Your Lordship, on those two occasions of bail that we have applied from the district court, on the first case, I was charge sheeted under 21A and 21B. However, when the charge was framed against me, it was framed under 21B. From my possession, it was only 4.61 grams. However, I was booked under intermediate quantity. Hence, for that reason, we need the intervention of this honorable court, Your Lordship, because bail has been granted to.
What is the stage of the case?
It's at present it's the examination of witness, Your Lordship.
How many witnesses are there?
There are around 20 witnesses in the first case.
Yes, Mr.
Lordship, in this matter, the accused person, Lordship, he was released on bail, but subsequently he was found to be involved in another NDPS case. Consequently, that earlier bail it was cancelled, and Lordship, the Honourable Court also had directed him to file a show cause as to why his bail should not be cancelled, but he did not file any show cause. So the court had cancelled his bail. Lordship, kindly come to
in
that
this
order.
case. In this case.
Yes, Lordship, cancel his bail.
Oh.
His bail has been cancelled.
Then you have come again for pray for bail or for
Prayer for bail, Your
overturning
Lordship.
the cancellation of bail order.
Your Lordship, so on that particular order, if Your Lordship may refer
Come
to
this,
page number
page 20, Lord.
20.
Page 20.
So, Your Lordship, on page number 23, if I may direct Your Lordship to point number 6.
Bail cancel.
Yes, point number 6 on page number 23, Your Lordship. So the court had already reiterated the order dated 16/10/2024, wherein the accused person and his defense counsel was informed, and at the same time was asked to show cause on 2nd December 2024.
Yes.
On that particular date, when he was available at the court had asked him as to show cause as to why his bail should not cancel. Now,
He did not file.
Yes, Your Lordship. So the defense counsel had taken a technical ground initially, and after that they had sought time to file proper show cause. However, it was rejected by the court. It clearly stated that this court does not deem it necessary to let me just read that.
Paragraph 8 and 9. Paragraph 8 and 9. The defense counsel first has taken a technical ground, thereafter he is seeking time. This court is not inclined to grant time. It is a matter of the court that the accused, who is on bail in the instant case for an alleged offence involving intermediate quantity, who was again arrested for an offence involving intermediate quantity by JPS case number 76-9-2024. Paragraph 9. The accused Stanky Merphet was released on bail by order dated 11-9-2023 with one of the conditions that the accused shall not indulge himself in any similar offence. It is a matter of record that the accused is found involved and arrested for a similar offence in JPS case number 76-9-2024. This court finds that if the accused person involved in the offence under NDPS Act are arrested and released only to be arrested again, it will be a mockery of the entire investigation and criminal proceeding. Bail granted to the accused Stanky Merphet by bail order dated 11-9-2023 passed in bail application number 8-2023 is hereby revoked.
Your Lordship,
The condition is that he should not involve in this similar offences, but he was involved again in another NDPS similar offence.
Your Lordship, I would like to highlight point number 8. If we look at the last portion, in this particular case, the second case, which is JOIPS case number 76-9 of 2024, the sections that have been charge sheeted is 21B, which is for intermediate quantity, and then we have 27 and 27A for trafficking. Now, if Your Lordship, if I may direct Your Lordship to page number 32 and 33, Your Lordship. This is the search memo. 32 is the search memo of one of the accused person, and the second accused person, who is my applicant in this case, is page number 33. Now on page number 32, Your Lordship may kindly look at point number 2. The type copy of this particular search memo is on page number 34. Point number 2 of page number 34 is the recovery made from Wanda Obare, one of the other co-accused. 5 containers golden tobacco tin was recovered, exhibit marked as exhibit 1 to exhibit 5. Now on the second page of 35, on point number 4, the golden tobacco tin which was recovered from my applicant was the last one, which is exhibit 6. If we go to page number 39, which is the type copy of the weight memo, Your Lordship, the last paragraph on page number 39, it states here that the weight of the suspected contraband along with the golden tobacco tin, exhibit 6, is 6.60 grams, and towards the end, if we look at, after deducting the weight of the plastic from the final weight, the amount of the suspected contraband is 0.31 grams and marked as S6, sorry, it's a mistype error, Your Lordship. Now, Your Lordship, on both cases, I have been arrested for small quantity. I do agree that I am a drug user. I am also undertaking that I will go ahead and go for any rehabilitation or de-addiction as Your Honor may deem fit and proper, and direct such kind of instructions to the applicant. And at the same time, I will go ahead and abide by all the terms and conditions that is set forth by this Honorable Court, Your Lordship.
Lordship, not only one contraband was seized, Lordship, different contraband was seized. If Your Lordship see this page 38, Lordship, different contrabands, Lordship.
Page number 38
is brief. This first paragraph, after deducting the last sentence, Lordship, after deducting the weight of the plastic from final weight, the amount of the suspected contraband is 1.07 gram and marked as S1. And after the next paragraph, the last sentence, after deducting the weight of the plastic from the final weight, the amount of the suspected contraband is 0.09 grams and marked as S2. Similarly, the next paragraph, the last sentence, after deducting the weight of the plastic from the final weight, the amount suspected contraband is 1.02 grams and marked as S3.
All these were seized from him?
No, Your Lordship. On page number 34, it is clearly mentioned that all these exhibit 1 to 5 is seized from The other co-accused, not from me. From me, it was only one golden tobacco tin, which is marked as Exhibit 6, and I've already highlighted that on page number 39, last paragraph 0.31. The others were from the other co-accused, Your Lordship.
But you are said to be in possession of an intermediate quantity. This is intermediate or a
Small quantity. 0.31 is small quantity, Your Lordship.
small quantity?
Yes, Your Lordship.
Actually, here it says 0.72 grams, isn't it?
Before extracting the weight of the empty heat seal plastic was measured, and the weight is 0.72 grams. This is the weight of the plastic, the heat seal plastic, Your Lordship.
Okay. And the substance is
The contraband,
1.03.
yes, Your Lordship, along with the weight plastic. So after deducting the weight,
not weight of plastic. After deducting the weight of the plastic.
After deducting, then it comes to 0.31 grams.
yes, Your Lordship.
So that is a small quantity.
But not only this, Lordship,
Anyway,
others also.
maybe. But if even, you see, in every individual case, if the quantity is still, small quantity, then
Your Lordship, the other fact is that I have been in judicial custody for 87 days on the prior case, and up till date, it's over 1 year.
as this court has observed earlier at the outset, what you can do is, it may not be necessary for you to, to insist on this application for bail.
Yes.
However, the court will give you the liberty to approach the trial court with an application under 64A. And the court will look into it.
Yes, Your
Definitely, it will have to.
Yes, Your Lordship.
Because that's your entitlement.
Yes, Your Lordship.
Pursuing this matter will not. So I'll dispose of this matter on that line. Okay.
Yes, Your Lordship.
So that's your submission then?
Just want to add some things, my friend. What happened is that the first bail application was cancelled. In the first case. Now, the certain condition which was fixed in the first case. Now, because of violation of that one condition, now that bail was cancelled. The second case is not cancelled. Only the first case.
That is why. See.
So we have approached twice. The ground that the trial court has taken cancelling the bail was because that the charge is framed under 21B. That is the ground. And the other reason is that about show cause. That show cause was not allowed. The court has.
We are not on that technicality.
Yes.
It's the opinion of the court that if you say that you have been arrested, in possession of small quantity, then you are eligible, to take recourse to 64A.
Exactly.
So the court will look into that.
Yes.
And if that is the case, and you are being allowed to go for rehabilitation, all these matters becomes, becomes academic.
Then in that case, Your Lordship, if such observation is given.
That's the observation I will give. I'll dispose of this matter on your submission.
That observation.
And give that observation.
If the trial court considers it.
The trial court will consider
Exactly.
Because before us, we don't have all the records, Lordship. Whether seized from him only
let them approach the trial court, and if nothing transpired, they can always come back.
Exactly. That observation should be there. Thank you.
We'll see.
supplementary list, item number 2.
My Lord, yesterday only I have received the appointment from as a LSC or ILC for the respondent number 2. So I need to go through the case. So I need time, Your Honor.
Lordship, last time Lordship, prosecution has stated before this honorable court that they will represent the both prosecution and the respondent number 2. So my humble submission, this matter may be heard. It's a bail application and I've been in judicial custody for more than Lordship 3 months, that is around 105 days. So my humble submission, Lordship, this matter be heard today. May I, Lordship?
Please, Your Lordship. Lordship, on that day, when the matter was listed before this.
No one is there for the state, Lordship. No one is there for the state.
In a report, Mr. Who's Mr. Stan? You are here in this case.
Henry Torrio. Henry Torrio.
Our Guru. Mr. Guru, but perhaps the timing, if I pray, if 10 minutes.
May I please, Your Lordship? Am I audible, my lord?
Yes, you are.
My lord, we were on the last date, my lord. I have read out to my lord the two star witnesses, my lord, in this case. So
My lord,
the
may I
ocular
please,
witness number one.
my lord, Mr. Gurung is in this case. He is with the brief of this case, my lord. So, my lord, if my friend can.
My lord, because of this delay in taxes from the government side, my lord, from the respondent side, I have already filed my bail application also, my lord. Of course, it was rejected earlier. And my
Where's Mr. Guru?
My lord, he was around here, but when the courts were on the transit, my lord, so if my lord can fix it next week, any day, not even 1 week, 3 days, my lord. Today is Thursday, so.
Oh, but he can continue.
My
yes,
lord.
Because
My lord, in presence of Mr. Gurung, it would have been better so that he can keep a note and he can reply adequately, my lord. But
there are two senior government advocates.
no, it is not about that. It is
With due respect to them, my lord.
with due respect, my lord. It will be proper if with the brief, my lord. If the hearing, I sit down and keep a note of it. Without the brief, my lord, it is tomorrow, my lord. In the supplementary list, we can. .304, I believe the section. Next week, my lord.
No, what more do you have to submit, Mr. Yubit?
My lord, yes, my lord. There are other witnesses, my lord. Those other witnesses are not important at all, my lord. But the IO will be important, my lord. Then thereafter, my lord, I will show, my lord, how the evidences were appreciated by the learned court below, my lord. And to my humble submissions, my lord, these appreciations was very much wrong, my lord. Because now the star witnesses, PW1 and PW9, they were supposed to be the ocular witnesses. And on the last occasions, I've shown to my lord whether they qualified, even qualified to be a star witnesses. When they say, when the fight begins, we ran away from the place. So now the question was that who is there who has really seen the overt act by the two convicted persons, my lord, by whose fatal blow the person succumbed to injuries, my lord. So this was it. Apparently, there was a group fight, my lord. A group fight. Everyone was running scatter and helter,
Okay. That in the parking place.
Molongon, yes, my lord. That is the case, my lord. Now, so the two star witnesses which I have read to my lord will recollect that none of them have ever said that yes, I saw these two persons hitting the diseased person. Now, more important than
Mr.
that,
Guru
my
is
lord,
here.
more important than
He can
yes,
We are waiting for you. See.
I'm sorry, my lord.
Yes, missed out his turn because of you.
Yes, please continue. Please continue.
Please continue.
Yeah. So now,
Okay, order has been passed.
My lord.
He has his case with you, thinking that you had gone home for lunch and not be back for next 3 hours.
We'll have it next week, my lord. Sure. We'll continue.
Mr. Yubit can continue.
Okay.
So my lord, the more important than that is, my lord, the TIP, my lord. The manner in which that test identification parade was conducted was also very irregular, my lord. Now the magistrate who conducted the TIP was never examined, my lord. And convicting the accused persons solely on the basis of TIP, my lord. In the TIP saying that yes, I identified this person. Yes, I identified these persons were there, my lord. So this is bad, This is what I on the last occasions, my lord, I came to that to that extent of submitting, my lord. Now today, my lord, I will just take my lord to other witnesses, my lord. And my lord will come to the deposition of now my lord, the deposition of PW2, my lord. It's page 58, my lord. Page 58.
Just a moment. Page 58.
Yes, my lord.
PW2.
Yes, my lord. This is PW2. His name is Milton and Sangma, my lord. He is a police, my lord.
Okay.
So, may I read, my lord?
Yes.
I joined the police department in the year 1983 as a constable, and I got promotion as a head constable in the year 2008. I was on duty at Bara Bazar. I do not recollect the date of the incident, but I remember that I received a phone call from OC KP Singh, who is the OC of Cantonment Bean House. On receiving the telephone call through mobile from him, he informed me that there was an accident in the parking lot just nearby at Cantonment Bean House. On receiving the telephone call, I immediately proceeded to the parking lot with some of the CRP personnel. On reaching the place of occurrence, I found one person was lying on the ground, and on seeing that person, I immediately called KP Singh OC of Cantonment Bean House, informing me about the man lying in the parking lot. And the OC of the Cantonment Bean House informed me through telephone that he will send one vehicle to the parking lot. On arriving of the vehicle, I shifted the seriously injured person inside the vehicle and proceeded towards civil hospital. And after admitting the injured person in the hospital, I went back to my duty. Now, in a cross-examination, he says, my lord, at page 59, I do not know anything about what happened to the injured person and who and how he was injured. I knew that person when I shifted to civil hospital, he was still alive. So, mere fact that he found one body lying there, apart from that, he does not know, and he assisted in taking the body to the hospital. Apart from that, he doesn't know anything about who is involved, who were involved in the fight, or who is responsible for the person's injury. He doesn't know anything. So, my lord, that now come to my lord, page 60. That is a deposition of PW3, my lord.
Yes.
This is Srimati Irisha Solang, my lord. Irisha Solang, it says, I was born and brought up at Maureen Maungap village, and still I am residing there till date. I have been married to my husband, Sri Kraukupar Wanyam, for the last 6 years. My lord, I'll just pause a moment. Who is Kraukupar Wanyam? Kraukupar Wanyam is one of the accused person who was initially arrested, and subsequently in the TIP he was not identified. That's why he was let off. So he's the same person, my lord. So the police is making his wife as a prosecution witness here. So he says that my husband Sri Kraukupar Wanyam for the last 6 years, and I have 2 children from him. I do not remember the date, year, and month, but I remember that it was Sunday, and I received a phone call from my husband, Kraukupar, who was driving a local taxi and also used to earn his living by driving a local taxi from Osindrom to Shillong. And on that day, that is Sunday, I received a phone call from my husband telling me that he is having a quarrel relating to some parking fees in which my husband has not given me the details of the parking lot in which he is having a quarrel relating to the parking fees. On the same, which is on Sunday, I received phone call at around 10 p.m. informing me that my husband has been arrested, but I do not know who has made the phone call to me. And on the next day, I went to visit my husband at the Cantonment Bean House. But this witness was declared as a hostile. Don't know for what reason, my lord. And then the cross-examination, it is not a fact that the police has seized the mobile of my husband, Shri Cooper Wanyam, from my possession. It is a fact that the mobile of my husband, which was seized by the police from my possession, was handed to me by Louis Tudong. Exhibit 1 is a scissor list dated 28/03/2011, and Exhibit 1 by 1 is my initial. On being shown to me today in the court, the mobile handset Exhibit 1, I do not recollect whether it was the same mobile handset. I do not know the person, Sri Louis Tudong. By face, I only met him once in the court premises. Now the cross-examination, my lord, I do not know the person Louis, but I came to know through my grandmother. I do not know about the incident of this case, my lord. So, my lord, this witness also is not much help to the prosecutions, my lord. So therefore, nothing can be relied on this, my lord, except for the fact is saying that husband was having some quarrel, and evening he gets arrested, and he doesn't know for what reason he gets arrested also, my lord. Now, my lord, PW4 62, my lord. PW4 at 62.
Yes.
The possession of PW4. My lord has got page 62.
Yes, yes.
The possession of PW4 taken on, my lord, he is Raining Karsandi, my lord. Now, I have been residing at Maurang Maunga for the past 28 years. Till date, I do not remember the date and year of the incident. But I remember that it was on Sunday that my daughter Irisha Solang, PW3, came to inform me that her husband, Shri Cooper Wanim, was arrested at Anjali Shillong. I received the information from my daughter, the arrest of her husband, at around 10 p.m. And the information was received by her through telephone by some of his friends. And I told my daughter that we cannot do anything now as it was already night time. And moreover, my village Maurang is quite far from Shillong. On the next day, my wife, Srimati Felista Walang, along with my daughter, Irisha Solang, came to Shillong to inquire more about the arrest of my son-in-law. And I went to my daily work as I am earning my income as a sumo driver, and I do not know anything about this. So, my lord, this prosecution witness also, my lord, throws no light to support the case of the prosecutions. So, now, my lord, page 63, this is doctor, my lord. Is a doctor, deposition of PW5, my lord. The PW5 is a doctor.
Yes.
Dr. Roland Don. Is that I joined the medical professions on 18th January 1986. During 2011, I was posted as senior health officer in the post-mortem unit office of the district medical health officer, East Khasi Hills, Shillong. In this case, I had conducted the post-mortem on the body of late Rigid Purkalam, 30 years old male, son of Sri Wanbok so and so. The body was brought to the hospital at 6:30 p.m. and morgue on 27 p.m. On 20/03/2011 at 7 p.m. An examination was conducted on 21/03/2011 at 12:10 p.m. The body was identified in the morgue by S.I.P.K. Singh, Cantonment Beat House. Number 2, Bhagyamjit Kurkalam, brother of the deceased. And number 3, G. Nonkandri, stepfather. And number 4, Balaji Nonkandri. The body was rigor mortis. Height is 5 feet 3 inches with a tattoo mark on the right arm, upper arm, tattoo of a dagger. Wounds in the body. There was a bruise on the right eye. There was a punctured stab injury wound, 2.2 into 0.8 centimeter on the back, 0.12 centimeter from the neck midline below scapula, and there is another stab injury above the left nipple with bruise running around the wound. Deep abrasion lateral side of the knee, 3 by 5.1 centimeter. Another injury abrasion 2 by 1 centimeter below the knee lateral, and another injury abrasion marked left partial parietal vision. The wound is already stitched. Another injury laceration 1 by 0.2 centimeter right cheek on the nostril. Examination of cranium, skull and vertebrae. Injury, laceration, scalp 2.5. Another injury, depressed, fractured on left parietal bone. Examination of brain spinal cord, hematoma on the left cerebral hemisphere region, blood stain, cerebral spinal cord. In my opinion, cause of death was due to head and chest injuries. Head and chest injuries Exhibit 2 is a post-mortem report, and so is my signature. Now in a cross, my lord, so the cause of the death was stab, chest injuries, and head injuries, my lord. Head injuries. Now, and it was caused by, apparently it was caused by some sharp object, my lord. Now, it said cross examination by Mrs. A.V. Lindo, so and so. I cannot say how many hours the deceased died, but post-mortem was conducted within 36 hours of his death. I could not say whether there is any sample of alcohol in the victim's body. The penetrating injuries in the chest may have been caused by the sharp weapon. On the side of the head was caused by some blunt weapon. It is a case of unnatural death. It is a case of unnatural death. So it says that a sharp weapon and some blunt object is the cost of the death. Now, my lord will see the next witness is page 65. Page 65, deposition of PW7 taken on oath, my lord. I have received some.
Where is the post-mortem report?
The post-mortem report is, my lord, at page.
So all these have been recorded in the post-mortem report.
Yes, my lord.
Page 85. Page 84, my lord.
Oh. So he has exhibited the post-mortem report.
Yes, my lord. He has exhibited also page 84, my lord. So my lord, page 84, 87, my lord, is a typed copy.
Yes.
So page 89, my lord, is a description.
Any
more detailed description of
any seizure of a alleged weapon?
No, my lord. In this case, no weapons has been seized, my lord. Page 89, my lord, will find is a typed copy, my lord. My lord will find more detailed description of injury and disease of the deceased. Page 89, my lord, is a typed copy.
Yes.
My lord, may I just read, my lord?
Yes.
As described, this is a body of a male person in Rego Mortis, a case at about 3 p.m. He was assaulted by unknown persons armed with weapons at Mollonghat. He was shifted to Civil Hospital Shillong, succumbed to his injuries, and after some time, due to profuse bleeding from the head and chest wounds caused by stab injury to the chest wall puncturing the left lung, and head injury caused by a blunt, heavy object, hammer, etc. So, my lord, so this is what the doctor said, my lord. Now, my lord, will come back to Doctor 67, my lord. Page 65, my lord. That is a PW7.
Yes.
My lord, yes. In the year 2011, I was posted at Shillong Civil Hospital and was doing emergency duty. One person, Babyanjit Kurkalang, was brought by police. Gentlemen, on examination of the patient was fully conscious, pulse 80 pm, BP 120 by 80, chest clear, cardiovascular system normal. On local examination, there was pain and tenderness over the left side of the scalp and also on the left on the left back of the chest. The patient was not admitted in the hospital. Cross-examination. The injury sustained by Babejit Kurkalang was fresh. I agree that Babejit is totally fit and healthy at the time of examination. So, my lord, this is the person who initially had a fight in the parking lot. And he says that he was assaulted, my lord. But the medical examination says that there was some bruises. There are some bruises only, my lord. Now, my lord, this is the magistrate, my lord, Srimati K.M. Lindo, page 67. Page 67 is a magistrate, my lord.
Yes.
She is the one who examined, my lord, under section 164. So she said, I received someone to appear before this court today. In the year 2011, I was posted at Shillong as Judicial Magistrate First Class at Shillong. And at present, I'm posted as a Chief Judicial Magistrate Nagpur. I'm aware why I'm summoned to the court today, and I am also aware that I had recorded a statement of the witnesses in this case. The witnesses whose statement I had recorded were the prosecution witnesses. Exhibit 5 is a statement recorded by me of Sylvester Conceit. Exhibit 501 is my signature. On the reverse page of Exhibit 5, to the best of my recollection, the deposition made by the witnesses was made in Khasi, but I did not need to interpret as I am well conversant with Khasi language. I have recorded whatever the witness has stated before me. Exhibit 6 is a statement recorded by me of Sri Babyanjit Kurkalang, and Exhibit 6 by 1 is my signature. On the reverse of the Exhibit 6, the witness Sri Babyanjit Kurkalang was the brother of the deceased and also the one who had lodged the FIR before the police. The witness has also deposed in Khasi, and since I am well conversant with Khasi language, therefore no interpretation was required. That is all I have to say. Cross-examination by defense, my lord. I do not remember the timing, but I recorded the statement during court hours. It is a fact that the time of recording the statement, Sylvester Conceit, the witness, did not know the name of the accused. Sylvester Conceit, the witness, did not know the name of the accused person when the incident had happened. It is a fact that the witness, Sylvester Conceit, did not give the physical description of the person involved, but stated that he saw one of them carrying a hammer. The witness had only mentioned the date, but the time, and also stated that the time of the incident was collecting fees. In a statement recorded by me, witness Babyanjit Kurkalang had mentioned that the name of Kokmius Totodong, Krakupar, Wanim, and others person who had assaulted me and my brother. The witness had mentioned the incident had occurred around 2 p.m. my lord. So now, my lord, here Sylvester did not know the name of the assailant, and neither he gave any description. On the other hand, Babyanjit named the accused person, which means that Babyanjit already knew the accused persons.
Babyanjit was the deceased.
No, Babyanjit is the brother, the one who lodged an FIR. Babyanjit is the one who lodged an FIR. He is a brother of the deceased. Now, on the last day, my lord, I have now, my lord, having said that, my lord, now it is important to read again the deposition of PW9. That's the following page, 68, my lord, page 68. What did he say, my lord, about Babyanjit Kurkalang? He said, I have received someone to appear before this court today.
He is a complainant.
And I am also aware as to why yes, complainant, my lord. I have received a summon to appear before this court today, and I am also aware as to why I have been summoned before this court today. The instant case is with regard to the murder of my brother, late Vijit Kurkalang. On 20th March 2000, at around 2:30 p.m., while I was collecting the parking fees at Anjali parking lot, I saw two boys sitting in a local taxi consuming beer. I asked for the parking fees from them, but they refused to give Since these two boys were refusing to give the parking fee, I called my brother Rigid Korkala. In some other statements, my lord will remember, he said that 5 to 6 persons were sitting in the taxi. In the FIR, my lord will remember, he said that 5 to 6 people were sitting. And here in the depositions, my lord, he says 2 persons were sitting in the taxi. After some time, my deceased brother came to the spot and we had a quarrel with these 2 persons who were not paying the parking fees. And after some time, both these persons left the place, leaving a local taxi export. Later on, after some time, these 2 persons came back again, along with other people who were armed with hammer, iron rod, dagger, and assaulted us. And out of fear, I managed to flee from the scene, but these people continued to assault my elder brother, and after assaulting him, they fled away from the place. After I fled away from the place, I went straight home and informed the relatives, and later on, we were informed that the police had reached the spot and saw my brother, who was badly injured, and took him to civil hospital Shillong for medical treatment. But unfortunately, later on, succumbed to his injuries on the same day. Later on, we received a phone call from our friends who were working as parking lot attendee, and they told us that my injured brother has been shifted to Shillong Civil Hospital, Shillong, by the police. And on receiving the said information, I, along with my relatives, immediately rushed to the Civil Hospital Shillong, and we reached Civil Hospital Shillong. He was bandaged and was conscious, but later, 10 to 20 minutes, he succumbed to his injuries. Later on, I lodged the FIR. The FIR was written by the in charge of so and so, so and so. I also remember I was asked to identify in a test identity parade. Now, my lord, in 164 statement, he made a mention of commerce. This is what the magistrate who recorded 164 statement said. Here, apparently, he doesn't know who is commerce.
Okay.
So therefore, so how did the name came about? So something is, my lord, not right in the case itself, my lord. So now, depositions of PW10, my lord.
Yes.
Here's the deposition of PW10. In the year 2011, I was posted as Sada PS as second OC on 20th of March 2011.
And this is, he's an official witness, not so important.
Yes, my lord. So we'll just skip this one, my lord.
Because there is no denial of the FIR being acknowledged and filed.
Yes, that's no, so my lord, we can skip this, and also, my lord, we can skip the next witness also, my lord. Sudip Biswas, deposition of PW11, my lord.
Okay.
This also we can skip now. Now we'll come to the IO, my lord.
Yes.
Prasad, my lord.
Yes.
KP Singh. Deposition of PW12, my lord. In the year 2011, I was posted at Cantonment Beat House as in charge. I am the OC of the instant case. The case was reported to Cantonment Beat House on 20/03/2011 on the same date at about 2:30 p.m. And it was a holy. 3 persons, namely Sri Kraukupar Wanyam, Sri Komias Dotudong, and Sri Dotudong Mosindram and Mongam, appeared at Beat House and verbally reported that their vehicle, Tata Indica bearing registration number ML047493, was damaged by some people, and all of them were assaulted by many people. Accordingly, they were sent to Civil Hospital Shillong for medical examination, and Head Constable M.N. Sama, who was on patrolling duty at Molonghar area, was directed to take care of the damaged vehicle. On arrival at the spot, the head constable informed me that one injured person is lying near the damaged vehicle. Accordingly, the injured person was shifted to Civil Hospital Shillong for medical examination. The first party who were sent for medical examination returned Beat House and so shows injured. The damaged vehicle bearing registration number was seized and brought to the Beat House. The first FIR was filed by Sri Kraukupar Wanyam regarding the damaged vehicle, and a separate case was registered under section 427/323 IPC, and it was registered by Shillong Sadar PS case. While the process was going on at about 6:10 p.m., I received a telephone call from Police Assistant Wood Civil Hospital, Shillong, that the injured person, Richard Kurkalam, who was admitted in hospital, succumbed to his injuries in the hospital. Then I rushed to Civil Hospital, Shillong, and kept the first 3 persons at Bid House. On arrival at Civil Hospital, Shillong, I found a big crowd as the deceased was a member of the Khasi Students' Union. I conducted an inquest over the dead body and found some repair wound injury mark on the chest, on the left side of the chest and head. The body was forwarded to SDNHO, Civil Hospital, Shillong, for doing post-mortem examination. I had also prepared the inquest report in connection with the instant case. Exhibit 8 is the inquest report dated 20/03/2011, prepared by me, and Exhibit 8/1 is my signature. I returned back to the Bid House, and the first 3 persons who were detained in Bid House, I found only 2 persons, Comius and Kraukupal. After some time, one of the eyewitness, Sylvester Comsit, appeared and identified Cornelius as the prime accused. A written FIR was filed by Babinjit Kurkalan, brother of the deceased, and this instant case was registered by Shillong PS case number, and Cornelius, Dotudong, and Kraukupal were arrested on the same day and forwarded to the court on 21/03/2011. And during the course of the investigation, 1 mobile phone with 2 SIM cards were seized by me on being produced by Srimati Onisha Solam, wife of so-and-so, and the same was seized at the Bid House. The name of the company of the so-and-so, okay, my lord. Now, my lord, we go post-mortem. My lord, we will skip the post-mortem. We have just seen the post-mortem, my lord. Exhibit 10 is the dead body. Then 161 statement, it talks about 161. Exhibit 12 is Caesar list. Then my lord will come to during the course of investigation. My lord has got a point.
Yes.
During the course of investigation, TIP was conducted in the jail premises, and the same was conducted
With
on
page?
7/4/2000. I'm sorry.
You're reading page?
My lord, I'm reading page number 76, my lord. The third last paragraph, my lord, from the bottom.
Oh, yes.
Page 76. During the course of.
Yes.
During the course of the investigation, TIP was conducted at the jail premises, and the same was conducted on 7/4/2011 at the jail premises, where the witnesses Babinjit Kurkalang and Sylvester Council identified Comius and Kraukupar 1 year. Kraukupar could not be identified. On 06/04/2000, the mobile set off was seized from possession of Louis, and the said mobile was used by the accused Comius Dudrom. Exhibit 13 is a so-and-so. Again, my lord, during the course of the investigation, Sri Louis Dudrom, in compliance with the order passed by the District Council Court, had appeared before me on 6/4/2011, and I have seized 1 mobile phone from him, and later on I had also served a notice to appear for TIP on 7/4/2011 to be conducted at jail premises, to which the accused did not appear. On the day when TIP was conducted, Louis was found absent. Now, my lord, on 19/4/2011, the Honorable Court has asked a report regarding the seizure of vehicle. The MVI report was received and the vehicle was released on Zima as per court order. On 02/5/2011, I received a copy of the court order issued by Honorable Court of the District Council, where the Honorable Court has vacated the interim pre-arrest granted to accused Louis. Then on 03/05/2011, NBWA against Louis Totodong was issued by Honorable Court of CGM Shillong, and effort was made to execute the NBWA. On 08/07/2011, a copy of the order was received from Senior Government Advocate, High Court, directing me to produce the case diary. Accordingly, the case diary was produced before the Honorable High Court. On perusal of the case diary, the Honorable High Court has directed the accused to surrender before the police. Accordingly, on 28/07/2011, The accused Louis Totodon surrendered. His statement recorded. He was arrested and forwarded to Honorable Court on 29/07/2011, and he was granted 7 days police custody. On 05/08/2011, he was re-forwarded to the Honorable Court after expiry police custody, and on, my lord, and on 26/08/2011, TIP was conducted in a jail premises, and Cyril Sylvester identified the accused, Louis Totodon. Now, my lord, all this while there was a maintenance that he could identify only one person.
Yes.
All this one. Now the other person gets identified out of the blue, my lord. Now, accused Louis Totodon was granted bail. So. Now, my lord, at the end of the investigation, it was believed that it was not a pre-planned murder, but happened due to sudden provocation. So I charge sheeted the case against Comius and Louis by charge sheet number under section 30434 and submitted a prayer to the court to discharge the accused Cooper 1A as he was not identified at the time of the TIP. So, my lord, the charge sheet, since the prosecution witness did not identify a particular person, therefore we have no case against this person. And since the prosecution witness have identified these two persons, therefore I have a material evidences to prosecute against these two persons. So what does it mean, my lord? It means that the entire case lies only on the TIP, my lord. TIP. Now, my lord, we're going to cross examinations, my lord. I will just take my lord to the TIP, my lord. Page 99 is a TIP, my lord. Page 99 is a TIP, my lord, and page 98. My lord, may kindly come to page 98, my lord, before page 99.
Yes.
So, page 98, my lord will see in the bottom, before the seal, I Rumbui JMFC.
Yes. This is not,
So
it's
he
not
is a person,
98 not so clear.
I'm sorry.
98 is not
It is
so
not
clear.
so clear, my lord.
Where's the type copy?
Round seal. Next page. I'm sorry, my lord.
Type copy?
Type copy is down there.
98?
Page 99 onwards, but unfortunately in the type copy, my
No,
lord, we did not
no, there's no
see,
type.
my lord.
There's no type copy of this.
No, my lord, type copy is there. At page 100, my lord, type copy is there.
Page 100?
Page 100, my lord.
No.
Page 100.
Okay, this one. Page 97 is what?
Mano, that is the continuation. Page 27, these are the post-mortem, the TIP, the columns, my lord, where it is written a date and time of conducting identification.
Yes.
The type copy of page 97 is page 99, my lord.
Yes.
Page 99. So I just wanted to point out, my lord, page 98, the seal, the round seal of the judicial magistrate first class. Judicial magistrate first class, my lord has noted that.
Yes.
And it was conducted by I Rumbui JMFC. And the date of this, the date is 7/4/2011, my lord, is shown.
Yes.
Now, my lord.
Yes.
Judicial magistrate, the person who has conducted the TIP, my lord, was never examined or never brought before the court, my lord, for examination. So, what is the consequences? What is the consequences of not bringing the magistrate who conducted the examinations, my lord?
Yes.
And the consequences of this is, my lord, it's my lord can see 2021. I think we have supplied the judgment, my lord. 2021 17 SEC 616. On the last day, my lord, we
Yes.
have handed over. We have handed over this the judgment, my lord.
Yes.
And this is a case of Umesh Chandra and others, and the Supreme Court, while dealing with on this point, my lord,
Yes.
from para 5, my lord, may I just read para 5? What it says, my lord? Para 5 of the judgment, my lord. It says that Miss Vibhadatta Makhija, learned senior counsel appearing for one of the appellants, submitted that conviction based on TIP is unsustainable as no TIP has been proved to have been held in accordance with law. The same thing here, my lord. The TIP was never proved that it was held in accordance with law. Repeated TIPs have been held only after which the appellants are stated to have been identified. Now, 2 TIPs were held, my lord. The first TIP, one person was identified, not satisfied. They arrested the other person, allowed him to go for a TIP, and now gets identified by overriding all the, whatever he has said that previously he has identified only one person. Now, my lord, PW2 is, I'm continuing, my lord.
Yes.
Identified. Now, PW1 did not identify any of the appellants. PW2 is stated to have been identified the appellants in the 3rd or the 4th round. Repeated TIPs whereas nullify the whole identification. The appellants have been acquitted on the charge under Section 412 IPC, the TIP being only corroborative evidence. In absence of any substantive evidence connecting them to the crime, the conviction is not sustainable. One other accused has been acquitted by the trial court itself for lack of identification. 2 others who were tried separately have been acquitted. We'll just escape a few paragraphs from paragraph 8, my lord.
Yes.
Paragraph 8. We have considered the submissions on behalf of the parties. The FIR was registered against unknown persons. The case of the prosecution solely rests on identification in the TIP. The acquittal of the appellants under Section 412 IPC and the Arms Act has attained finality. No doubt, the case identification period was conducted after a month of the occurrence. It has also to be kept in mind that PW2 was a minor at the age of 13 years at the time of the occurrence. Number 9. A case identification period under Section 9 of the Evidence Act is not substantive evidence in a criminal prosecution, but is only corroborative evidence. The purpose of holding a test identification period during the stage of investigation is only to ensure that the investigating agency prima facie was proceeding in the right direction, where the accused may be unknown or there was a fleeting glance of the accused. Mere identification in the test identification period therefore cannot form the substantive basis for conviction unless there are other facts and circumstances corroborating identification. But more important than that, the test identification period being a part of the investigation has to be proved by the prosecution as having been held in accordance with law. The onus lies on the prosecution to establish that the TIP was held in accordance with law. It is only after the prosecution prima facie establishes a valid TIP having been held, the question of considering any objection to the same arises. If the prosecution has failed to establish that the TIP was properly held by examining the witnesses to the same, there is nothing for the accused to disprove. In the present case, a magistrate is stated to have conducted TIP. The magistrate has not been examined. No explanation is forthcoming why the magistrate was not examined. The only evidence available is that of PW4, the station house officer, and during the investigation, the TIP was held in district jail. 9 Little and identifies the proceedings of court. The identification of the proceeding is irrelevant, as obviously he could not have proved the presence during the TIP part. So, my lord, holding this, my lord, in this case, the accused were discharged, my lord, and the TIP which was purportedly held was declared to be bad, my lord. So exactly, my lord, the facts and circumstances in this case is very much similar to my case, my lord, which I'm presenting before my lord. My lord, the IO has said, I am filing the charge sheet. Why I'm filing the charge sheet? Because the two persons has been identified, one person has not been identified. Very well, my lord. But then where is the proof? Where is the proof? The law says that it's not, your TIP is not a substantive proof of evidence. And if it's not a substantive proof of evidence, then you need to prove in the course, in the process, in the process of the trial. And that explanation has never come forward, my lord. Therefore, my lord, this conviction cannot sustain, my lord. Now, my lord, coming back to the impugned judgment, I have read, my lord, all the evidences. Now, my lord, will go to the, my lord, before that, 313, my lord. My lord, in the 313, all the accusations, my lord, all the statements, the incriminating statements that was put against were all be denied, my lord. 313. The 313 is at page. My 313 is a supplementary paper book, my lord. Supplementary paper book, page 1, my lord.
Yes.
Page 2, my lord. Page 2 of the supplementary paper book, my lord.
This is
my lord has got.
This is 313.
Yes, my lord, 313. 313. My lord, it says that PW1,
Yes.
Sri Sylvester conceived in his evidence at deposed that I know about the case. It was Sunday, Holy Festival in the year 2011. He, younger brother of the deceased, called out his own brother, who was also with me at that time. After that, we went to the spot. The incident had already taken place, and 4 to 5 people came to us and started assaulting both the brothers of the deceased. But they did not do anything to me. I can identify only one out of the 4 or 5 people who had beaten up the brother of the deceased on that day. And the accused is present in the court and court brother. And he had also identified the pointed towards you as one of the person who had assaulted the victim and his brother. He says, I deny the same and said that he might have been mistaken. So my lord, others are not worth reading, my lord, because it's all been denied, my lord.
Okay.
So, my lord, now we'll come to the judgment, my lord.
Yes.
Page 124 is the impugned judgment. Page 122, my lord. Page 125. My lord will see the points of determination. What points? The points of determination. Whether the accused commutes to the wrong. My lord has got
Yes,
125.
yes.
Whether the accused commutes Dutodong and Louis Dutodong in furtherance of their common intention on 20/03/2000 at around 2 p.m. had severely assaulted Babenjit Kurkalam and his elder brother Rijit Kurkalam at Maulanga, Shillong, where Rijit Kurkalam suffered serious injuries and thereby succumbed to his injuries and thereby liable to be punished under section 304 or 35. Now, the issue, the point of determination was framed as whether there was an assault by these two brothers.
Yeah.
So that was the, so we'll have to bring out, yes, these two persons are the one who assaulted. So my lord, argument, we will not go to the argument part, my lord. And my lord will skip few evidence. My lord, I have just shown evidence adduced by the prosecution also, so we will not discuss that, my lord, now. So we will go to how the evidences were appreciated, my lord. We'll go to para.
Yes.
Discussion and finding, my lord. Page 143, my lord. Discussion and finding. Page 143, my lord. Paragraph 85 onwards.
Yes.
So, my lord, page 86, the London Trial Court first defined what is 304 IPC, my lord, and also defined what is definition of the culpable homicide. And she has cited few examples of the few judgments, my lord.
Yes.
She discussed few judgments. And so we can skip that also, my lord, and then we'll come to paragraph 90, my lord. Paragraph 90. From my lord has got that's one page 149, paragraph 90.
Yes.
Yes. Yes, sir. From the evidence adduced, there is no denial to the fact that a disease-led Rijit Kurkalam died at Civil Hospital Shillong on 20/03/2011. Inquest over the dead body was conducted by PW12, the IO, on the same date, and the said dead and the found repair wound injury mark on the left side, chest and head. Exhibit A is an inquest report prepared by PW12. The post-mortem was conducted by PW5, where the dead body of late Rijit Kurkalam was brought to the hospital at 6:30 p.m. and the morgue at 7 p.m. The dead body was identified by PW12 and PW9. The post-mortem examination was conducted on at 12 p.m. Exhibit 2 is a post-mortem. From the evidence of PW5, it is clear and established that a disease did not die of a natural death, where he clearly stated in his cross-examination that it is a case of unnatural death. As PW5 on the examination of the disease, my lord. So, my lord, this is also not much relevant to us, my lord, because it is not nowhere it is a denial that, my lord, the person died. The person died of some injuries, my lord.
Yes.
It's not a denial, my lord. But the question was that who was responsible for it, my lord? Now, again, page 95 also talk about PW5 only, my lord. Now, page 96, so the two most important witnesses of prosecution are PW1, who is a friend of the disease, and PW9, who is a brother of the disease. Who is a brother? With regard to this identification disease person, it is established that the accused Comias and Lewis were present on the day of the incident and assaulted the disease.
Page.
Page, my lord, that's page 150. Page 150, my lord.
Okay, para 97.
Yes, my lord, para 97. With regard to the identification of the accused person, it is established that the accused Comias and Lewis were present on the day of the incident and assaulted the deceased and PW9. From the evidence of PW12, it is found that during the course of his investigation, the TIP was conducted firstly on 7/4, where PW9 identified accused Comias, and in the second TIP conducted on 26/8/2011, after accused Lewis surrendered, PW1 identified Lewis. During the recording of the evidence before the court, PW1 again identified Lewis, and both the accused. Coming back to the incident again, evidence of PW1 and PW9 are important. PW9, who is the brother of the deceased on the day of the incident,
at around 2 p.m. was found to be collecting parking fees at Anjali Park and saw the accused person sitting in a local taxi and consuming beer. He asked the accused person from the parking fees, but they refused to give. Since they refused to give, PWN called up his brother and the deceased Rigid, who after some time came to the spot. When the deceased came to the spot, they had a quarrel with the accused person who refused to pay the parking fee. The accused persons, after quarreling, left the place, leaving the local taxi at the spot. PW1 confirmed that the deceased victim was with him at Foreign Market, Bara Bazaar, when the deceased received the phone call. And 100, my lord. Further, it is found at PW9 that after some time the accused deceased came back again along with other people who were armed with hammer, iron rod, dagger, and assaulted them. And out of fear, PW9 managed to flee away from the scene. But the accused persons, along with the other people, continued to assault the deceased victim. And after assaulting the deceased victim, they fled away. This is also confirmed by PW1, where he stated that they reached the spot and the incident had already taken place, and 4 or 5 people came to them and started assaulting both the brothers, but they did not do anything to him. PW2 was also confirmed that the fight occurred due to a heated quarreling about the parking fees. From the evidence of PW12, it is found that on the day of the incident, he was at the beat house where the 3 persons, Krau Cooper, Wanin, Comios, and Lewis, appeared at the beat house and verbally reported that the vehicle was damaged by some people and all of them were assaulted by some people. Then PW1 made a phone call through who was on duty, Barabaza, informing him that there was an incident in the parking lot. PW2, on receiving the said call, immediately proceeded to parking lot with some CRP personnel and found one person lying on the ground. And on seeing this, he immediately called up PW12 and informed PW2 and then sent a vehicle. When the vehicle arrived, PW2 shifted a serious interest. So the fact that the deceased was alone in the parking lot is confirmed by PW9, where he stated that he managed to flee away and went straight home to inform the relatives. So PW9, after being informed, rushed to the hospital, my lord. Now, yes. So, my lord, again, now in these statements, my lord, nowhere actually my lord will see that nowhere there's a finding, the concrete finding that these 2 persons are responsible. Even the magistrate, there's no finding. So, my lord, and magistrate relied on a TIP. He said that all TIP was conducted and all the collaboration with the TIP, the sequence of events, what had happened, who was present, who was not present. There's so much of contradictory and vague areas. This was never examined, my lord. And citing few other Supreme Court judgments, my lord, it went to convict, my lord. The court said that the court is of the considered opinion that the prosecution is able to establish a case against the accused persons under section 304 part 2 IPC and convicted them under section 304, my lord. Therefore, my lord, I've read out to my lord all the relevant aspects, and even the relevant aspects I've read out to my lord, and even the irrelevant parts which is not that I try to be fair and read out to my lord. From nowhere, my lord, not even the whisper, my lord, any remotely connecting, my lord, to the overt act of the individual, my lord, to the overt act of the individual. Therefore, my lord, this is a case not for a conviction, my lord. And the prosecutions, and apparently there was a group fight. There was a group fight. Now, the person who, if there was a group fight, my lord, and if you have to convict somebody for 304 or for abetment of section conspiracy section 34, my lord, yes, then all 5-6 of them should have been convicted. Where are they? It's a single out, my lord. It's completely a single out and a witch hunting, my lord. It's nothing else. Therefore, my lord, in my humble submissions, my lord, I would humbly pray, my lord, to set aside the impugned judgment of convictions and also the impugned sentence, my lord, and set the persons at liberty, my lord. That is all I have to submit, my lord.
Okay.
You'll do it today or next day?
As per the convenience of the court, madam.
it's already lunchtime.
1:15 lunchtime, my lord, yes. We can continue tomorrow. I'm coming back tomorrow, my lord, if it's not inconvenient to my lord and my learned senior.
My lord, tomorrow I have lots of matters, my lord. So I think it may not be convenient tomorrow, my lord. We'll have it next week. No?
Wait, can we take one case now? Can we? Dari atau sepuluh dan ini TV ini sepuluh kan lai.
Huh? 13 is fine, my lord, in my calendar.
14. 14. So 14 then.
14.
My lord, 14, my lord.
Heard Mr. P. Owen, Mayor Counsel for the appellant, who has continued with the argument, who has concluded his argument. What is argument? Mr. Argung, Director GA, has submitted that he will reply on behalf of the state respondent on the next date. Accordingly, as agreed to by the parties, this is matter for further hearing on 14.
14, my lord. Good day. The next is the same, my lord.